Hello everyone, welcome to Court with Krissy. For your viewing pleasure today, two short but equally satisfying court clips. First up, a young man appears before Judge Simpson to ask for permission to leave the state for a family vacation. Where's the fam going? Las Vegas. And then a hooligan heads to court to fight for his right to do hooligan things. I hope you like it. Court with Krissy is now in session.
Court calls case People versus Vincent de Chavez.
Mr. Ganatra for the people.
Dovey isn't talking to that guy, so
What's your name?
it's Vincent de Chavez.
Okay.
We're doing the preliminary exam.
Your Honor, Mr. de Chavez is indicating that he wishes to have a preliminary examination. Is that correct?
Yeah.
Okay.
Joy Gaines, Senior Assistant Public Defender.
And discovery is all complete? To your knowledge?
To my knowledge, Your Honor.
Would people have their witnesses available the 13th?
Yeah, the court would kindly put it to a later date.
Any objection to the 22nd?
No.
To the 20th?
I also had a trip planned to Las Vegas back in June before I was aware of this matter here. And I was wondering if I could get permission to leave the state.
You're going with your family, as my recollection did not work previously.
Okay, well, hold on a moment. Preliminary examination in person will be set for August 20th, 2024, 9 a.m. That's before Judge Fresh Hour. All right. And then
I think so. I just asked him, his vacation includes that August 20th date?
No, it's the 9th through the 13th.
Oh, the 9th through the 13th. Oh, so the first court date. So the 9th through the 13th, he's supposed to be going on vacation with his family. I believe it's
Las Vegas.
Yeah.
Yes.
A restitution of this is $2,733.74. Maybe he comes back and can pay that off. He's also hiding out with honesty.
We're gonna let him go to Vegas, so that good luck to you. Don't play blackjack. No, that's me. Anyway, what date are you leaving?
The 9th.
August 9th?
Yep.
Through August 13th?
Correct.
All right. Defendant may travel to Las Vegas August 9th through the 13th. Otherwise, bond will continue with its conditions.
All right. Thank you, Your Honor.
Thank you.
All right, Mr. Quinn is here. I have two cases that you're on, Mr. Brown, as well as an informal hearing, or is it a formal?
It's informal.
It's an informal hearing, okay. And I do see there's an officer here. Let's do your cases first, Mr. Brown. How would you like to proceed on those?
Your Honor, he has been charged with 2 counts, the same charge. There has been an offer to plead to one of the counts, dismiss the other count. They're both 90-day misdemeanors. I have had conversations with Mr. Quinn regarding this. However, at this time, he would like to set this matter for a jury trial.
All right, and that would be both matters, correct, Mr. Brown?
Both matters, yes.
All right. Mr. Quinn, that is your request. That's your request. You're entitled to that. Is that your request at this time? Summary, it looks like you're saying yes, but I can't hear you.
Yes, Your Honor.
Okay, now I can. Thank you. All right. Those will be set. Ms. Brooker, can they be heard at the same time?
Well, they're unrelated. So I don't know how Mr. Brown would feel about consolidation in that case.
Mr. Brown?
That is an issue I have not spoken with Mr. Quinn about. They're unrelated incidents. They are the same charges. I don't know if the
I think
witnesses are
that
going
might
to
be
be the same.
I could see some argument that it's prejudicial. You know, for instance, the jury says, yeah, he did this one or not this one, or we're going to come up with a compromise verdict. I suspect we should just do them one at a time. I'm only going to set one, then we'll see what happens and go on to the next. Ms. Brooker, do you have a preference? Which goes first?
No, Judge.
All right. I'll let Pam, if you can just set whichever one of the two
Sure.
first. We'll have a jury status conference just before. Obviously, a jury trial is going to be in person. The jury status conference is just before, Mr. Quinn. That will be by Zoom, same way we're doing this right now. But so we'll send out that notice and we'll let you know when it is. All right. I also have an informal hearing, Ms. Brooker and Mr. Brown. I know neither of you are involved in that. I'm assuming Officer Cherry, since you're here, that is your ticket. Yeah, I see your name in that. Is that correct?
That's correct, Your Honor.
All right. So I'd ask both of you, Mr. Cherry and Mr. Quinn, if you'd each raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Yes.
All right. And Mr. Quinn, just so you know, this is a civil infraction. It's not a crime like the other two that were charged are. So you're not entitled to a jury trial. It's just a bench trial, for lack of a better term in this. And the burden of proof is a preponderance of the evidence, not beyond a reasonable doubt. So I'll hear from Officer Cherry. I'll hear from you. If I have any questions, I'll ask them, and then I'll make my decision. So Officer Cherry, go ahead, please.
Thank you, Your Honor. On Tuesday, February 6th of 2024, I was forwarded a complaint from a member of the public that revolved around a YouTube video that was uploaded online by a YouTube channel called Hooligan UTV. I won't get into too much of the complaint since those are open cases, but the initial complaint stated that a group of side-by-sides were riding through various counties in Otsego and made statements that were that they were going to intentionally damage groomed snowmobile trails. So I launched an investigation into that complaint. I did, as part of that investigation, I did check to see if a permit was pulled through the department for an event on state land. This event was advertised on the Hooligan page, which was later to be discovered to be run by Colton Quinn, the defendant. I had the staff check to see if a permit was pulled, which would be required based on the nature of the event. There was no permit pulled, whether under Hooligan UTV or Colton Quinn. Our department does specifically outline for group ORV rides on state land. There's two factors that would require a permit to be pulled. One is if there's an entry fee. To my knowledge, there was not. The other is if there's 20 or more people. The video itself was titled, that was uploaded by Hooligan UTV, was titled Hooligan Group Ride, 20 side-by-sides take over Michigan's snowmobile trails. In this video, Mr. Quinn states himself that they had 20 machines they started with, which would then meet the requirement that a permit would have to be pulled. This ride occurred on January 27th. It was advertised on his Facebook page. So after attempting to contact Colton Quinn, it ultimately led to a civil infraction ticket being issued for that permit not being pulled.
All right, excuse my ignorance, but what's a side-by-side?
Side-by-side is a type of off-road vehicle, different than a quad or a dirt bike. It's a larger, resembles more of a motor vehicle, like four wheels and a roll cage and doors, but it is a type of off-road vehicle.
But this was in the winter, I take it.
That is correct, Your Honor. It was January 27th was when this ride occurred.
But you actually viewed the video that showed at least some of these side-by-sides out there on the property?
That's correct.
Okay. All right, thank you. Mr. Quinn, what did you want to say?
I'd like to remarks about the snow tearing up the trails were all sarcasm.
Mr. Quinn, if you could get a little bit closer to your microphone, it was breaking up. That'll probably be better. Go ahead. Well, there's still a little bit of, I can't always hear you.
Is this okay?
Yes, it is.
Okay, the remarks made about tearing up snowmobile trails were all sarcasm. We posted that we were going to go for a ride, and we got a lot of hate over it, and snowmobilers were telling us to stay off the trails and stuff like that. Michigan has 6,500 miles of snowmobile-only trails, and we plan to ride the trails around the campground, which we met on private land. Never intended to take the group ride off of private land, but just so happened people did go off of private land as a group. But as far as tearing up the trails, it was all sarcasm, and I think this should be dropped because we're on private land, and I cannot control where people go after they leave the group ride.
All right. You know, the charge isn't tearing up the property or anything like that. I mean, it's just having an event without a permit. You know, much of there's no restitution being sought. This is just a, like I said, it's a civil infraction. I don't know if it's related to the other two cases or not, and it really doesn't matter because those proofs are completely different, and because there'll be a jury there anyway, the jury won't have heard anything of this in that regard. But I do find that, you know, even though I don't really doubt you that it was sarcasm, obviously some snowmobilers did not think it was sarcasm. Officer Cherry viewed the event. I will find you responsible. I want to stress once again, this is a civil infraction. It's not jail or probation. It's not allowed by law. It's simply a fine situation. The fine for that is $140. Are you able to pay that today?
I am not, but I'm sorry, Judge. We're on private land was my argument against that.
I do understand. I do understand that, but it also went on to public land. And, you know, the implication was, even though that was, at least this is my finding, that because there was a statement, even though you say sarcasm, that you were going to go and tear up some trails, that would be public in that regard. And that's...
none of that was true at all.
Yeah, I understand, but that wasn't what was published there. So I've made my finding. It's an informal hearing. As things go, it is about the equivalent of a 5 or 10 mile per hour speeding ticket. So that's, these hearings are brief. So are you able to pay that today, or do you need some time?
I definitely need some time. I only make $10 an hour, Your Honor, and things are tough right now.
Okay. I'll give you 30 days to pay. I'll give you the number to call to pay it. Are you ready?
Yes.
989-73. Did you get it?
Yep, thank you.
Okay, we're all set then. We'll send out the notice concerning at least the one trial soon. Thank you very much. All right, moving next to Holly Bowen.